Imagine this. You're driving home late at night and the police pull you over for a broken taillight. The officer orders you out of the car. Nervous and confused, you ask, "Why am I being stopped?" You hesitate before stepping out, and suddenly you're facing a resisting arrest charge under Penal Code Section 148A. Sounds crazy, right? But you didn't swing, you didn't punch, you didn't even run. But under California law, even hesitation or questioning an officer can get you prosecuted for delaying an officer's performance of their lawful duties. I'm Nana Knight. I'm a former prosecutor and a certified criminal law specialist, and in this video, I'm exposing how simple confusion during contact with the police can turn into criminal charges against you and what you can do to stay out of jail. So now let's talk about what is resisting arrest under Penal Code Section 148A. This California Penal Code section makes it illegal to resist, delay, or obstruct a peace officer or a public officer or an emergency medical technician while they're lawfully performing their duties. It doesn't just mean fighting the police. It could include things like interfering with a witness interview, for example, or blocking access to a crime scene, refusing to give your name during booking, or even minor delays when the officers are doing their job. Now let's look at the elements that the prosecutor must prove in order to convict you for resisting arrest under Penal Code Section 148A. The prosecutor must prove several things. Number one, they have to show that the officer or the EMT was lawfully performing or trying to perform their duties. Number two, they have to show that you resisted or you delayed or obstructed or all those three, and you did this on purpose. Number three, they have to show that you knew or you should have known that the peace officer, the EMT, or the public officer were performing these duties, and that's the knowledge requirement. If any one of these elements breaks down, the whole case against you can collapse. But here's what matters. The arrest or the detention must be lawful, and the officer's use of force to arrest you must also be reasonable. And here's the key takeaway. A police officer is not lawfully performing their duties, for example, if they're detaining someone unlawfully. And most importantly, they're not lawfully performing their duties if they're using unreasonable or excessive force against you during the arrest. So what is excessive force? There's a definition of that. There's a few factors that the courts look at. The force must be objectively reasonable under the Fourth Amendment. And here's what most people don't realize. An officer's use of force or actions are not judged by their personal opinions or their intent, but whether a reasonable officer in the same situation would have acted in the same way. In one landmark Supreme Court case of Graham versus Connor from 1989, the Supreme Court said, we can't look at an officer's actions with a 20/20 hindsight or based on whether things turn out badly or well. Instead, the court said, we must look at all the facts and the circumstances of each case. For example, we have to consider the severity or the seriousness of the crime. We have to look to see if the suspect is an immediate threat to the officers or other parties. Another factor is if the suspect was trying to actively resist arrest. If the suspect was trying to flee from the scene, that's another factor. The courts also look to see what the officer knew at the time the officer was using force. What pressures and split-second decisions were they facing? Would another reasonable officer standing in their shoes also think that level of force was necessary to effectuate the arrest? It's not about whether the officer felt justified, and it's not about whether the public afterwards thinks that the situation looks bad. It's about whether the use of force made sense to a reasonable, trained officer in the same moment with the same information about what was happening in that moment. But what if the officers say that you were delaying arrest by taking photos or recording them? Well, most people don't realize this, but it's not a crime to take a photo or make an audio or a video recording as long as you are in a place that you have a right to be. For example, a public sidewalk. Let's look at some other real-world examples of how people get arrested for resisting arrest. If, for example, the police order someone to sit down and they say this several times and the person doesn't comply, this could be a violation of Penal Code Section 148A. Another example is a situation where somebody's too drunk. They're too drunk to comply with the officer's orders. Is this considered resisting arrest? No. A passed out man who's dragged to a patrol car, for example, and this is from a real case, is not guilty because he didn't act willfully. He's not acting on purpose. He's just drunk. He's unable to comply because of his intoxication. Another example is situations, and these are pretty common, is when somebody's fleeing or trying to hide from the police. Running from the police or hiding when the police are trying to arrest them is considered resisting. That meets the elements of the Penal Code Section 148A. Another example is refusing to cooperate during booking. This is considered a violation of Penal Code Section 148A. In another case, refusing to give a name was enough for a conviction. Another situation is if you're refusing to remove a hand from your pocket or resisting shackles that the officers are attempting to place on you. Giving a false name is another example of a violation of Penal Code Section 148A. Lying about your name or your identity could potentially be construed as an obstruction. Blocking officers, refusing to step aside is considered potentially delaying an investigation, and you could be arrested. So what are the penalties if you're convicted of a violation of Penal Code Section 148A? You could face up to 1 year in county jail. You could face up to $1,000 in fines, or both. And even without jail, the conviction can ruin your record. It could cost you your job or affect your immigration status. Let's look at some defenses that actually work. You could argue that the officer wasn't acting lawfully, that they were using excessive force. And if you can show that the officer was using excessive force, this could potentially void the charge against you. Defense number 2, you could argue that the officer was not lawfully performing their duties because the arrest or the detention was not lawful. You could argue that you did not act willfully or on purpose, or you can argue that you didn't delay if your hesitation, for example, was minor, it wasn't criminal conduct. These are defenses that are potentially available to you if you're facing a violation or a charge of resisting arrest. But every case is unique. Every case is going to have different facts and circumstances. So it's important you talk to a lawyer and figure out what is the best defense strategy. Now let's talk about how we defend individuals who are accused of violating Penal Code Section 148A. To give you an example, someone was recently accused of resisting after they refused to get into the patrol car. The police officer claimed that this person was delaying and obstructing, but the body cam showed that he was simply asking why he was being arrested, and this was enough for the charge to not be filed. What is your best move if you're accused of resisting arrest? You have to act fast. If you act quickly, an experienced criminal defense lawyer can review every second of the body camera footage and the videos and file potentially a motion to suppress if your rights were violated. They can push for a dismissal or they can push for a diversion, which means that your case can get taken out of the criminal justice system and you can be afforded an opportunity to essentially earn your dismissal. Depending on the fact of your case, we can also challenge the unlawful arrest or the detention. If we go into conventional litigation, we can cross-examine the police officer who arrested you or other police officer witnesses on whether their actions were lawful. We can also show the prosecutor the weaknesses in their case and show them that it's not possible to prove the case beyond a reasonable doubt, which is the standard at trial. And in some cases, we can also, if you act fast, of course, keep the case from ever being filed with the district attorney's office. Dismissal isn't luck. It's a strategy, and if you're facing a resisting arrest charge in California, don't hesitate to contact my office. We do offer a consultation, and we can provide you with a plan of action to get your life back. And speaking of resisting arrest charges in California, what if you did nothing but defend yourself in a situation where you're being attacked? Check out this next video where I break down the ins and outs of self-defense law in California, and I'll see you over there.